afternoon, ladies and gentlemen. This is the first session after the lunch break, and this is the first site session number 1. My name is Plamen Angyov. I'm Head of Activity for Justice and Home Affairs and the Policy and Consultation Unit at the EDPS, and I have the pleasure to moderate this panel, which is dedicated, as you know from the agenda, but let me just recall what we are going to talk about: access to data, balancing between effective law enforcement and mass surveillance. Why this topic? Seems a bit quite self-evident, but still, let me just recall what was already extensively mentioned during the morning sessions about the rapid and quite inevitable digital transformation of virtually all aspects of our daily lives. And law enforcement and criminal justice are no exception to this rule. While the original paradigm of reconciling the security needs with fundamental rights, and in particular the right to privacy and data protection, remains as valid as initially, finding the fair and, I would say, generally acceptable balance proved to be extremely difficult. On one hand, the privacy advocate pointing out, who are warning that actually some of the measures like general and indiscriminate retention of data and access to this data for law enforcement purposes or national security could infringe on our fundamental rights and freedoms, sometimes even amounting to a mass surveillance. On the other hand, the law enforcement community, and not only, are making the point that restricting access or making impossible access to potential electronic evidence may actually bring or offer impunity to some criminals, especially those active online. Acknowledging that the EU is at a really critical juncture, not only in the law enforcement, no need to repeat the geopolitical situation that we are all, but still the EU, as always, has tried to chart a way forward. In this case, the European Commission and the Council, or maybe I should say the Council and the European Commission, because this is as the initiative, created the so-called high-level expert group on access to data for effective law enforcement. From now on, I'll just refer as the high-level group, no need to repeat the whole name. And this high-level group, for those that are following the topic should know quite well, came at the end of last year with 42 recommendations clustered in in 3 blocks: capacity building, cooperation with industry, and legislation. Not surprisingly, the recommendations were met with mixed reactions by the different stakeholders, from strong support to criticism. The task of this panel in this context is to discuss and to help us, first of all, better understand what is at stake, what we are discussing, what we are trying to achieve, and I would say even the most important objective, and is to identify possible points of convergence on which we could build a compromise in the future. I'm truly honored to be in this panel dealing with this important task with an exceptional panel with 5 remarkable speakers with extensive knowledge of what we are discussing, representing EU institutions, civil society, industry, and data protection community. And very quickly about the organization of the debate, which is slightly different from the previous. Instead of looking at the bigger picture, of course, we will touch upon, each of the 5 speakers will answer to 3 questions, which are designed to zoom in, to shed light on a specific aspect of the puzzle or piece of puzzle. And hopefully at the end, we will have a picture that is maybe multifaceted, colorful, but still useful. And now, sorry. I never thought that but my webcam is that much less useful than I thought initially. So, come on. No, it's... So, probably this was interruption before a key part of the discussion, and this is presenting the 5 speakers. I mentioned how important they are for this topic. Let me start with the order they are going to speak, not of any order of priority, just the internal organization. Ignacio Gomez Navarro is a team leader in the Security in the Digital Age unit of the European Commission, Director General for Migration and Home Affairs, or briefly DG Home. Before joining the Commission, actually, he was on the other side. I'm joking, of course, but he was part of the data protection community as a legal officer in the Secretariat of the European Data Protection Board. And before that, he also served as a senior counsel in the Secretariat General of the Interpol. Next, Chloe Barthélemy, no need to be presented. I mean, I think quite well known, but still, let me just recall that she is Senior Policy Advisor at EDRI, the European Digital Rights Network of over 50 organizations and experts, which have the aim of promoting and defending human rights in the digital age. Within EDRI, Chloe is leading the advocacy work on state surveillance, law enforcement, data protection. I think that you know that's why she is on the panel. Moving next, Michel Combeau is the director, recently appointed, quite recently appointed director of the Technology and Innovation Department of the French Data Protection Authority, CNIL. Before joining CNIL, Michel worked as a member of the board, actually as Director General of the French Federation of Telecoms, and also as a part of the board of directors of Digital Europe and the European Association of Internet Service Providers. So quite extensive knowledge, not only about the data protection, but also the industry. Talking about industry, we have Laureline Hood, the Director for EU Government Affairs at Microsoft, dealing with EU policy files on data protection, law enforcement, online safety. Before joining Microsoft, she was at different positions, various positions, at Proximus and Orange, and for all those that are in Belgium, there is no need for further introduction about her technical expertise in the telecommunication and data retention. And she also worked as a lawyer in different law firms in Brussels and in Stockholm. Last but definitely not least, Kazimierz Ujazdowski. Sorry, I'm also speaking Slavic mother tongue, but Polish is always a bit of a challenging. I hope, Kazika, I'm not saying it rightly. He is currently the head of the justice section at the Polish permanent representation to the EU, and representing the Council and the presidency of the Council. However, before moving to the permanent representation, he was member of the cabinet of the European Data Protection Supervisor. And also before that, I'm working, again, into the Polish civil Ministry of Justice, if I'm not wrong. Yes. So, without further ado, let me just start with the first round of questions. The recommendations of the high-level group, they start with actually a disclaimer that I'll quote that they should not be considered as a representative of the European Commission's official position. Nevertheless, as we heard also from the Director General of DG Justice and from other speakers this morning, the Commission is already working on certain proposals as a possible follow-up, in particular as regards data retention. My question to Ignacio is, what else should we expect and when?
Thank you, Plamen, for the question and for the invitation. It's a pleasure to be here and to see so many familiar faces from the data protection community. So indeed, as you said, the work of the high-level group, or the HLG as we call it, was experts-driven. It was launched by the Council Presidency. The discussions were co-chaired by the Commission and by the Council Presidency, and also the Commission served as a secretariat. But the recommendations themselves, the content of the report, they were always expert-driven. This is why we felt that it was important to emphasize it even more, have it emphasized with this caveat in the cover. So in terms of the recommendations, well, you may have already noticed that they have been echoed by certain institutions, such as the Council itself, the Council of the EU, last 12th of December, adopted 2 sets of recommendations on counterterrorism, but also on access to data, where it explicitly mentioned the need to ensure access data for law enforcement purposes, access to data, and even when as far as to ask the Commission to propose a roadmap on the specific recommendations made by the high-level group on access to data for effective law enforcement. As you also know, the new Commission just took over its functions last 1st of December, so it is still assessing what its political priorities, what the concrete actions it will take over the coming years. Although, based on the public statements that have already been made by the President of the European Commission herself, and also by the Commissioner for Home Affairs, Mr. Brunner, you can already see some indications of where the direction that will be taking. So, one thing is for certain, there will be a European internal security strategy for the coming years. This is being prepared as we speak, and access to data, of course, will feature prominently in this European internal security strategy. So the need to ensure lawful access to data for law enforcement purposes. Then you may have also noticed in the political guidelines that the President of the Commission presented for the coming years to the European Parliament, and also in the hearings, the questions and answers to Commissioner Brunner, that they mentioned that there was a need to bring up to date the tools available to law enforcement authorities to access data. And even more specifically, it was mentioned that there was a need to bring up to date the rules on data retention. So on data retention, even though, again, this is being considered as we speak, there will be a process launched, an impact assessment, of course, and there must be a very thorough impact assessment for this very complex issue, for which all the contributions we expect to receive many contributions, and from all sides, from all communities, including the data production community that is represented here. And then we'll see what comes out of this data protection impact assessment. This is one of the rare issues on law enforcement access to data where there seems to be a consensus, at least among different communities, on the need for harmonization at the EU level, whether it's from the data protection authorities, law enforcement authorities, industry, or even digital rights associations. There seems to be a call for harmonizing the current situation at the EU level. And so this is something that, of course, we will continue preparing. And if the impact assessment resulted in an identified need to adopt an EU instrument, this case should not be expected before next year. This is what I can advance. Then for other initiatives, many of the initiatives that the high-level group has mentioned are initiatives that are already ongoing, that have been supported by the EU over the last years. So this is something where the law enforcement authorities, they saw value, and the experts that were represented in this group, they saw value in continuing to promote them in areas such as digital forensics, training, capacity building to member states, and that could continue over the coming years. And of course, there will be also detailed analysis and discussions on the very complex and sensitive issue of access to encrypted data. This is something, again, that the Commission is aware of how complicated it is, how many different interests, rights, public interest, but also fundamental rights are at stake, as well as cybersecurity concerns. And it's something that we'll be following up closely, and of course, again, by trying to be as inclusive as possible in our reflection.
Thank you very much, Ignacio. Not surprisingly, data retention and access registration, initiative, let's not use registration, although there is this assumption that we may see a legislative proposal somewhere within the coming year, will feature quite prominently also in the questions to the other speakers. But let's move directly to Quorum to see the other take on high-level group. In December last year, over 50 organizations representing civil society, media, some regulated professions and business associations published a joint letter calling for the EU digital security agenda to promote fundamental rights and support a safe digital ecosystem. And please allow me just to quote one sentence from this joint letter. Efficiency should not be achieved at the expense of weakening fundamental rights, legal safeguards, and the European economy. So in this context, my question to Kuo is, what, in your opinion, are the three biggest risks for fundamental rights from stemming or related to the recommendations of the high-level group?
Thank you so much, and thank you for the invitation. Thank you for having us. As a general kind of introductory remark from EDRI's perspective, I just wanted to emphasize, before I give you the three big threats, that we fundamentally disagreed from the get-go about the objective of the high-level group going dark, or at least the premises upon which it developed its work and its recommendations. We don't think that we need increased access to data by law enforcement. The first reason is because it has not been properly documented or proven that there is actually a lack of data for law enforcement authorities. That data is not available, or there is unsurmountable obstacles during the course of investigative proceedings to access data, to access evidence. This has not been proven. And quite the contrary, this is our take, that we usually refer to the golden age of surveillance as privacy, data protection, digital rights activists, because there's never been so much data out there about individuals due to the business model of current online service providers. And then secondly, it has not been documented that increasing access to data by law enforcement, which will actually lead to more justice, or, for example, have an impact on crime clearance rates, if we decide that this is a good criteria to measure actual what is more security in Europe, or actually bringing more justice in Europe. Going to your question, the three big risks we see in those recommendations. So, like, out of the 42, which one do I highlight? First, encryption backdoors. No matter how many efforts were put in the reframing, rebranding of this idea, the proposal is there. It's the proposal to break the promise of encryption. And you can call it encryption front doors. You can call it lawful access by design. For us, it's all the same. It amounts to encryption backdoors, and that poses unacceptable risk to privacy and to cybersecurity, as was already mentioned. The recommendations related to this issue are kind of based on this 30-year-old problem of actually achieving access without undermining the security of everyone. And that the belief is that we can solve that 30-year-old problem, although it's totally unclear how. And I don't think the high-level group actually delivered on its mission to provide an answer for that. And certainly shifting the responsibility to the industry to find the solution isn't a good idea for us. Second is data retention. So recommendation number 27 is raising a lot of concerns for us. First, the scope of intermediaries, which is widened to all data handlers, quote unquote. That is obviously very worrying because it kind of creates the conditions for mass surveillance. It will cover OTTs and all type of service providers online. Very concerning. The obligation to generate data, so to actually collect data that certain service provider refuse to do. And yeah, that will kind of compromise their services and the security of their services. And it's actually a demand to end online anonymity. Quite worrying for us. And then the decryption obligation, which then refers to my previous point on encryption backdoors. Lastly, but not the least, the real-time interception proposals. We are in a context where spyware scandals are piling up. We know that state surveillance powers are being abused consistently by authorities. This is documented repeatedly. And we have this proposal to extend e-evidence rules to these very intrusive measures of real-time interception, turning our devices against us. So really worrying us as well for us.
Thank you very much, Kua. If you remember, I mentioned at the very beginning, one of the main, actually the main objective of this discussion is to try to find point of convergence and a stepping stone for future compromise. You see that it's quite going to be challenging, but we'll keep trying, I promise, until the very end of this discussion. And moving, probably Michel has the answers, representing France, a country that knows a few things about security challenges, but also about privacy. And so my question is, it's a bit more general, but I think that you can zoom on any aspect you would like in your question. And it is, how does effective yet privacy compliant policy on law enforcement access to data look like from the position of a data protection authority? What should be the safeguards, the guardrails to prevent this such effective policy creeping into mass surveillance?
Yes, and I guess thanks again for inviting Neil to participate in such an interesting debate. I have the honor to try to find a compromise between two visions around the access to data by the law enforcement forces. And I guess when you look at it from the privacy angle, it gives you perhaps a way to find that right balance. And again, the EDPB, where CNIL took a part of in it, published an opinion on the high-level group recommendation. And I guess first we have to recognize that there is a necessary balance to find between right and interest. The rights of people to live in a secured environment, but also the right of the people to have their privacy protected. And again, when you look at that balance, it was at the core of the creation of CNIL 47 years ago, when the first digital file was created by the police force in France. The parliament at that time, and we are back in 1978, decided to create CNIL, an independent authority, to try to balance the right for law enforcement forces to have modern tools to fight crimes, but at the same time protect the general population and their right to privacy. And I think when we look at, especially on the multiple decision from the European Court of Justice on data retention and access to data, we have some kind of a balance that has been built over years, and we really have to take into account that there is, yes, a right for law enforcement to access to data, because crime has to be fought. And clearly, with the development of the digital technologies, the law enforcement forces have to have the same tools to fight crimes. And again, this data retention and access to data should follow some principle: necessity, proportionality. And again, when we look at what the principle of the GDPR are, we clearly, can take them into account. That is, you have to have these, minimize the data that are, detained by the various service provider. Access to data should be to be monitored by independent authorities. Data conservation duration should be also as well limited to the right duration. And again, there's data and data. For example, IP address are not the same nature that location data. And clearly, when you look at all those principles, we can find a way to have a legitimate access to data. But again, I don't think we need to extend that legislation. EDPB, as I said, published an opinion, and EDP considers that a broad and a general obligation to return data in a written form and extend that obligation to every service provider is clearly not the right way to really have an effective access to data by law enforcement forces. So clearly in France we have some kind of a long story about that, and we, I guess, find the good path to have that balance. But balance has to be found, and clearly what we can take from the vice decision from the European Court of Justice, that there is, and the balance has to be maintained.
I will definitely tap into this 47 years of experience of CNIL with the follow-up questions. But now let me move to Warivin. And we have been, of course, we discuss and balancing between the rights of the individuals and the needs of law enforcement, security needs. Sometimes we forget an important stakeholder, and I would say also part of the equation, and this is the business. Because at the end of the day, many of these measures, and I think it was mentioned by Kuo that sometimes they are assigned. I mean, they have to figure out how to square the circle. However, my question is a bit more specific, and I would like to know, I'm really curious to know, is there a common position of the big representatives of the big tech, of the biggest players in the technology world? I mean, there's no need to mention all these acronyms that describe them, but is there a common position, or each company has its own approach, or it's saving itself in the best possible way it could?
So, thank you, Plamen. Thank you for having us here as a representative for industry. I'll try to answer your question, but before doing that, I'd like to highlight that you have different, there's different types of big tech and different sorts of operators. So I think that's a part of the answer already. We are a cloud provider and we have many services, but our main focus is the business segment. Okay. So going back to how we look at it, on the one hand, of course, we are subject to laws that oblige us to cooperate with justice, and we appreciate, we recognize that law enforcement is a very important critical factor in keeping our society, our services, our customers safe. So that's one thing. The other thing is, of course, we are also bound by data protection laws, and it is equally important for us to keep our customers protected in the sense of data protection and human rights, and both by law and as a matter of trust. So in that sense, for us, it's very important to follow these laws that are about shaping the cooperation of law enforcement with private sector. And we think it's very important to try to influence the debate so as to make sure that that these laws are respecting both sides of the equation. As we are a bit in the middle, we need to and as you said, sometimes there is a bit of tension. And what I forgot to mention actually is that in addition to being a bit in the middle between law enforcement and privacy, we also are a global player. And that makes it even more complex because often we are confronted with different laws at both sides of the spectrum, and you can have conflicts of laws. So very important for us to follow that debate closely. Let's put it like that. And I think if you look at it from that high level, most tech operators will have the same view. For example, in 2021, we contributed to and we signed a declaration. Declaration is maybe a big word, but a statement called the Trusted Cloud Principles. We did that together with AWS, IBM, Cisco, SAP, some more, Google, I think. And the idea is to, in this complex world, patchwork of sometimes imperfect, sometimes inconsistent law, what are the principles that bind us and what do we think is important? One of the elements that we put forward in that statement, for example, is the importance that we attach to providing transparency on the law enforcement requests and how that goes. So that's basically the answer. There is maybe one last point that I'd like to highlight, and it's a bit stating the evidence, but I'm nonetheless going to do it. So digital evidence is getting more and more important. Whether there's more evidence, I also don't have the answer, Chloe, to that. But digital evidence is getting more important, and that's normal. Our societies are getting more digital. So in a way, it's also normal that law enforcement is trying to look at laws to deal with this situation, how to gather efficiently digital evidence. One thing that we should not overlook, though, is that with digitalization, the privacy equation also becomes different. Because if you think about it, in an earlier world, when there was a warrant and the prosecutor or the police would go to the house and look maybe on the computer or on the shelves or I don't know what, the person incriminated would likely be able to exercise its rights of defense. And in a digital world, that's another situation. That is why it's so important to build in these safeguards so that the rights of defense can be properly exercised.
Thank you very much, and I promise that I'll give you the possibility to share your views, to have your voice heard, at least even at least in the format of this debate. Moving to Kazik. Poland is at the helm at the Council of the EU, actually. Okay, let's limit to the Council. Still, for the next 5 months, I think we're at the end of January already. Given the complexity of the matter, the need, as Ignacio explained, of a real, proper public discussion and impact assessment, it's not feasible to expect any real proposal put on the table by the Commission before the end of the Polish presidency. So, in this context, what is your role? I mean, how do you see the role of the presidency in this preparatory phase of the follow-up of the recommendations? And in other words, how do you plan to leave your mark of what is coming out of the work of the high-level group?
Thank you, Plamen, and good afternoon, everybody. It does feel a bit weird to speak on the EDPS event that I didn't contribute to the organization of. So, heartfelt thanks and congratulations to all of you in the EDPS who made this event a reality, and it's the second edition, and I think it's fantastic that we have it in Brussels on the Data Protection Day. And thank you for bringing this topic and for recognizing the role of the Council in this process. Maybe a few words of the context in which the presidency finds itself with the data retention and access to data situation. As some of you might know, the motto of the Polish presidency is Security Europe. Now, I guess there is probably various views in this room on whether it's a good motto or not, but I think it does represent a certain reality in which we exist now, or at least center understanding of a reality that leaders have in Europe. And that, I think, is not without meaning in the context of the debate we have today. Of course, I'm here as a presidency speaking on behalf of the entire Council, which is a bit tricky when it comes to topics like data retention. But what I could say, using my, let's say, Polish hat, is that, for many member states, the feeling of the threat to security has become recently more prominent, more problematic, and I think, if I can share, this has an impact on how the discussions evolve within the Council. I'm just stating this as a fact, not as a position. It's just where we are currently. You asked me what we're going to do with the high-level group. So first of all, I have a luxury of being responsible for the justice part, not the home part. So what the justice component will be dealing with, at least this is the position of the current presidency, is the potential work on data retention. So the richness of the report is subject to coordination within a so-called COSI working group. So it's a home affairs part of the Council. And maybe little asterisks, a little bit similar to what Ignacio said. However, whatever consensus has been reached around the report, it is not legally speaking binding on the council either. However, the council did acknowledge, as Ignacio mentioned, I think in December, the importance of this as a source of action plan for years to come. What the justice brings, as I said, is the whole data retention. And it's a valid question, what does it mean in practice if there's no data retention on the table? If there's no data retention on the table, there's of course no position of the council on the data retention topic. But what I think is important is, first of all, that this is justice. So it's a little bit marking the territory by the Polish presidency that in our view, any future work on legislative proposal from the Commission, and I guess from DG Home, in the context of the Council, would be dealt ideally in the justice working groups. This, in our view, captures best the the complexity of the matter at stake, and I presume gives more certainty that the process will be dealt with in a way that I think is more legally aware of the jurisprudence context that we will be finding ourselves in. What I would like to share, however, on the existing position of the member states is that I think there is a growing, maybe not consensus, but a growing understanding that the current situation of certain fragmentation is in the long term not sustainable and that we need more clarity. And then, on the other hand, you'd probably have some member states who are afraid that that clarity would mean, Tele2 copy-paste into legislation, something that they struggle with agreeing to. The view of the presidency is, however, that the situation has evolved compared to the Tele2 judgment. That there is certain trend that I think is an opportunity for the lawmaker to turn into something more tangible and legally stable for years to come. We can discuss this a little bit later, how that could look like. We have had discussions under the Hungarian presidency on the document, on so-called strategic guidelines document. It's not a very popular document, but it does exist. And in this document, member states committed to furthering the reflection on the data retention legislation. So as much as there is probably no consensus yet on how the legislation should look like, there is consensus, I think, that, or almost a consensus by, let's say, by a certain big member state, that such a legislative initiative should occur. There was, however, no consensus, unfortunately, from my perspective, on the idea for the admissibility of evidence directive. This is something that is rarely, I think, mentioned in the context of data retention debate. So myself, taking a little bit for a second off the hat of the presidency, I would like this to be in the EU legal framework as a also helping hand in the work on data retention, but that's probably not going to happen in the near future.
Thank you very much, Kazik. First of all, as regards case law and way forward, I saw Chloe smiling, so I'll follow up with a question to her. But before moving, and thank you actually for raising a point that is really important, but not that visible. Of course, the EU moved and member states quite away from the fruit from the poisonous tree, or whatever concept about accepting evidence that was gathered in a, let's say, doubtful circumstances. But still, I think it's a really very important, not only a legal question, but also important safeguard. But I'll not come back to this because this a bit extends out of the scope of what we're discussing. There was already a mentioning, let me just change a bit the perspective about the cross-border international aspect of what of access to data retention. And I'm turning back to Ignacio, but in a slightly different role. He has been personally involved quite extensively in international cooperation agreements on cooperation in criminal matters. And so my question is, again, from personal and from institutional experience as well, how do you ensure that the European standards on fundamental rights and freedoms are actually upheld in these international new instruments? Let me mention just two of them. The second additional protocol to the Budapest Convention. We had Council of Europe speaking at length in the morning, but also the very recent, fresh from the oven, UN Convention on Cybercrime. So how do you achieve, how do you manage to make sure that these international instruments are compliant with what we believe is important and crucial in the EU?
Thank you, Plamen. Well, I would say that as a start, one should assess the opportunity, whether it's worth engaging into a negotiation. And you should look at the general context. Is this a bilateral negotiation? Is this a multilateral negotiation with more than 146 countries sitting around the table, as was the case for the UN Convention against cybercrime? And look at the risk attached, and also and especially the risk attached to human rights. What is the risk of engaging into this process, and the risk resulting from this process to human rights, and what is the risk also of not engaging in this process? What is the risk of, what is the cost of having a no agreement? Is there a risk that other countries may try to steer this process to end up, so that we finally end up with a UN instrument that would go against the human rights and the values that we cherish in the EU? So this is the first step to take, whether it's worth or not engaging to this process. In the specific case of the UN Convention, we felt it was worth it, not just us in the EU and its member states, but also like-minded countries, such as the US, Canada, Australia, New Zealand, and others. And in the end, that's how it turned out to be, that it was worth engaging, and that the risk also that this process may be turned into, it may lead up to an instrument that would be contrary to the EU values was too great. And also that it was an opportunity not just to promote cooperation in criminal matters, but also to mainstream fundamental rights and human rights safeguards into international cooperation in criminal matters at the global level. So that's the first consideration. Then the second is, of course, it's necessary to be ambitious when it comes to human rights and pushing for human rights safeguards. Being ambitious while at the same time being conscious that, especially in the context of multilateral negotiations, there may be different approaches to reach the same end, and this applies also between like-minded countries. And also that the other states around the world may not be, in terms of legal framework, up to the same level, or may not be used to using human rights safeguards to the same level when it comes to their cooperation in criminal matters. So here, it's important to convey, not to try to impose your view on the others, but to persuade them, to show them how, rather than being a nuisance to cooperation, human rights can be an enabler. And this is what we did, for instance, during the UN negotiations. We told them, we have instruments such as the European Arrest Warrant, the European Investigation Orders, and other instruments that are the envy of some other regions in the world. And this is thanks to the strong human rights safeguards that we have embedded into the EU acquis and to the EU legal system. In order to have the same level of trust and international cooperation, we need to have strong human rights safeguards included into the agreement. So there is this very important task of persuading the other party of the need for these safeguards. And a good way to persuade them is, of course, to refer to already agreed instruments, such as the Budapest Convention on cybercrime, the UN Convention Against Transnational Organized Crime, and to build on them. To say, but in this case, even more safeguards are needed, and to explain why more safeguards are needed, especially in the digital space. Then something that proved very useful in the UN negotiations, for instance, was also ensuring the inclusivity of the negotiation of the process. It was also thanks to the role of civil society that were always there in the room, and their submissions and their pressure that we managed to have into the text human rights safeguards that are unprecedented in international instruments on cooperation in criminal matters. And then as a third point, I would say that, of course, it's very important to exclude from the scope of application of these instruments on cooperation in criminal matters conducts that will always be unacceptable. And this is also what we did. We pushed for excluding, adding general clauses to the convention that excluded conducts that would lead to the suppression of certain fundamental rights, or requests for cooperation that were motivated by discriminatory reasons, such as person's political opinions, sex, gender, religion, or others. So it's also very important to exclude these unacceptable conducts from the scope. Then what was also a red line for us and was very important was to ensure that EU legislation in the area of criminal matters, with all the safeguards it contains, remained unaffected by any result from these negotiations, that it could stay as it was, and especially that its safeguards, all the safeguards it contained, would not be watered down by reason of having to adhering to a future instrument. So this was a red line, and also something that we managed to preserve. As I said before, it's unrealistic to expect that we can simply copy-paste the whole EU framework and then make it applicable to the rest of the world when it comes to the detail of human rights safeguards. So at the very least, it was necessary to agree on some basic and robust human rights safeguards while providing for the possibility of the parties to an instrument to refuse cooperating, where this cooperation would lead one country to go against its own values and safeguards. So this was the case. For instance, this is one of the reasons why we really pushed and insisted on having a clause on the protection of personal data that enables states parties to refuse cooperating and providing mutual legal assistance to other parties, or even extraditing, if this goes against EU laws on data protection, governing data protection matters. So this is, again, an unprecedented ground for refusal that exists for the first time in a global instrument, but that could become mainstream in other future UN instruments. And then, but it's not the only one. There are also other solid grounds to refuse cooperating, such as the one I mentioned before, on prosecution motivated by discriminatory factors. And then, of course, essential interest clause on human rights, double criminality, and many other safeguards. And then, of course, there's the law, but there's also the practice. So we should not content ourselves with having a text that looks good on paper. It's also necessary to implement it and to ensure that it's implemented correctly by all parties. And this is where it becomes very important to have also reflected in the text review mechanisms of the instruments, to check every now and then, to regularly check how the convention is being implemented in practice. And it's also very important, especially for the EU and its member states, to be there supporting future states parties to the convention in their implementation, to make sure that the convention or any other instrument in criminal matters is implemented in conformity with its spirit and with its human rights safeguards. And this can be done through technical assistance, capacity building. We already have programs ongoing in the EU where we also with the support through the Council of Europe, such as the CJEU program, where we assist states becoming parties to whether it's the Budapest Convention or perhaps possibly in the future the UN Convention, in implementing them in a way that is in conformity with its human rights safeguards. And so yes, I think.
Thank you very much, Ignacio. We all sometimes complain that we reach a stalemate, we got stuck on registration between 27 member states. What about if this multiplied in the UN context to close to 200? So it's really appreciated, and the effort is, I mean, we should really see it from the perspective of, it's always more complicated. There's always a risk to get, the challenge could be bigger always. But as I promised to Chloe, that I'll give her the possibility to comment on the TV2 and the copy-paste remark by Kazik. So we know, I mean, there's quite a high level of certainty that there will be a proposal on data retention and access. So my question is a bit provocative, but from your point of view, what would be better? A new legislation codifying the quite extensive case law of the Court of Justice. I lost track of the number of judgments, even if we all know that it's quite complex, and for that reason and for other reasons often ignored by the member states, or to have a clean start, to have a new legal framework, which may be not perfect, nothing is perfect, but still simple and clear and much easier to be implemented, setting a level playing field in this. What is your take on this?
Thank you for the question. Everybody's looking with such a suspenseful eye. I'll reply provocatively too on the same tone. I think our preferred option would be from a rule of law perspective that member states finally respect CJEU jurisprudence, which they have ignored for more than 10 years now in many member states. So that would be our preferred option from this perspective. Respect the rule of law, implement the CJEU case law, stop ignoring it, and implement changes in your national frameworks. Okay, besides that, I understand the need to be constructive. And to answer your question, if we were talking about a new EU instrument, this is our kind of analysis that there isn't a lot of margin for maneuver anymore, that the court has left to EU legislators. The case law has become more detailed about what can be done and not. Honestly, it's easy to push the blame on the Court of Justice, but I would say it's the member states' fault because they kept on bringing new cases to the Court of Justice, asking for more preliminary rulings, asking the court, but what about my national specificity? Is it really what you said the last time? Can it not have an exception? And so it forced the court to be as detailed as possible and create exception, one of the latest being the Adopi setup. And so if I had to reply, we would be in favor of a legal framework that is clear, that is not too complicated indeed, but that would mean striking out those special cases, such as the Adopi system, and not starting to decide that on one case, access to an IP address and retention of an IP address is not a serious interference, and in another case, it is one. So that is starting to be too complicated. So we would very much like something more protective than actually where the court is going ahead.
Okay, that's really high wish of going beyond the court of justice. As a lawyer, I'll just not comment any further and just move directly to the next question. Again, changing a bit the course and looking at Michel and the French experience. Slightly different, not exactly access to digital evidence, but still, I believe, very relevant for the topic that we're discussing. Last year, there was the biggest sport event was in Paris, the Olympic and the Paralympic Games, actually. And the French government deployed some quite new advanced security technology, such as the augmented cameras, if I'm in publicly accessible spaces, which, by the way, were green-lighted by CNIL. Or at least, let's put it like this, there was a consultation procedure carried out by the government authority departments with the Data Protection Authority of France. So, are there any lessons learned that you would like to share with the other data protection authorities and more broadly from this experiment during the Olympic Games? Now we moved into a really provocative question, so I do hope that you will appreciate the way that the opportunity to really go into these questions, to answer them in advance.
Yes, indeed, and thanks for asking this question. As the evaluation committee that has been set up in the law that did authorize that experiment just published its report. So I have some data I can share with you on what came out of this experiment. First of all, even though this experiment was not green-lighted per se by CNIL, we did publish an opinion, and we work at early stage with the government to try to, let's say, build a framework that was a secure ring privacy rights for the people. First, on technical solution, to be sure that they were really secure by design and privacy built by design, and also setting out legal conditions, especially on the public information. Clearly, when you look at the evaluation committee report, let's say the results are uneven from the technical performance point of view. And clearly, it does really depend on the context of use and the technical characteristic of the cameras. Clearly, for example, cameras that were positioned at low 8 in a satisfactory lighting condition were able to detect the entry of individuals into areas and without leading to too many false positives. On the other hand, the number of detection error will be particularly high if a camera is used at a great height to detect lost objects. So clearly, we could see that there were contrasts in the results, and we did learn a lot from those experiments. And clearly, we don't think at CNIR that the Olympic Games were the right moment to test those technology, because it really depends on the context of use and with the number of police forces present. In areas where there were a lot of police persons, clearly the cameras did not add specific value on security. But sometimes, if you don't have any enough police presence, and if the police personnel can intervene quite rapidly, then there were some interesting useful use cases where the number of false positives was very low. And so clearly, let's say uneven results. Some will say much to do about nothing, but clearly, when you look at from the police forces point of view, they were generally satisfied with the technology. It was read in common rooms, and it was seen as a complementary tools to monitor what was happening on the field. And also from the general public point of view, clearly the information was quite useful. The evaluation committee conducted a general survey on what was the opinion on the general public, and 90% of those questions were very broadly in favor of using video protection in public spaces, even with artificial intelligence enhanced cameras. And clearly, but the person that were questioned also identify potential pitfalls. For example, a majority felt that AI will trivialize general surveillance or could be misused. So clearly, let's say the population was in favor of that, but it did acknowledge that there was, some potential impact on their privacy rights. And furthermore, which is quite interesting as well, that when they were asked about priorities for guaranteeing public safety, the population, the persons first cited increasing the number of police officers on the ground or recruiting people specialized in new types of risk, well ahead of investing in AI-equipped videos. So clearly, there's, it's the technology was in some cases working well, not in all cases. And clearly, when you have a lot of police forces on the ground, then the let's say the impact was really not that relevant. So the public debate will go on in France, and especially at the Parliament, because the Parliament will be, responsible for either reconducting the experiments, either to make it permanent, or either to stop it. And clearly, we did learn a lot from that experiment. I would say we will still work with the government and the Parliament to give us opinion and try to put as many safeguards as possible to protect the privacy rights from the people. And also, we all acknowledge that in some use cases, that kind of cameras are quite useful.
Thank you very much for answering to this question. And actually, my take is that the assessment is quite nuanced. the verdict is still out there. It's not delivered yet. You said it's just recently published, the report, or it was issued, or is it going to be public? Oh, okay, so we are looking forward to really reading, as I said, lessons learned from France. Now, back to Lorraine, and a bit bridging with the previous reply about, of course, the service providers as addressees of legislation are quite different in business models, in size, in technology used. So the question maybe sounds a bit self-evident, but still, I would like to ask, what is your preference? I mean, from the position, of course, of your company, should we go for, when it comes to especially data retention and access, for a universal solution, one size that fits all, with same rules, same obligations for all service providers that are within the scope, or we should go for a bespoke approach tailored exactly based on the business model, the size, and other characteristics of the service providers?
Okay, thank you. So before going your question, just so clarifying where our position on data retention. So I think Kajik and Chloe have said it both. The situation in Europe is, sorry to say, messy. Some countries still have their data retention laws in place. Others have abolished it. Others are changing it, have changed it, and so forth. We are a global tech provider, and we don't have 27 separate databases. We don't have like localized national databases. That's not how our systems work. And so if we then are confronted with different regimes in different countries or different requirements, different timings, different data sets, and we have to comply with that per country, it's sorry to say, it's basically incompatible with other requirements like the GDPR and the data minimization obligation that we have. So add to that most of the messaging apps are nomadic. That's why they're called number independent interpersonal services. So that it makes it all the more difficult it gets very confusing. Anyhow, so if there is a data retention obligation, yes, then we are in favor of having a harmonized one. That's clear. And then for us, I think maybe this is, I don't, it's not like a big dogmatic thing, but I think the most logical would be to apply it to all interpersonal communication services. But there are maybe a few more smaller focus points to pay attention to. For example, imagine that you apply it to all interpersonal service communications providers, but that you follow the case law of the court, which says we can think of targeted data retention in function of geographic high crime criteria. Imagine that a legislator would decide to follow that. Then, of course, you need to make sure that operators can localize the data. And if that's, for example, our messaging apps, they work, we don't have native location information, not mobile and not fixed, because it's the IP address and it's super inaccurate, basically. So if we were to have to apply a geographic data retention obligation, we would either have to keep everything or nothing. So that's it. So these are technical elements that you need to take into account. And then a smaller thing is maybe like, look, we speak a lot about the balance between data, between law enforcement and data protection. We speak very little about the balance between data retention and the freedom to conduct a business, Article 16. And so imagine that you would see that there are certain groups of providers that get very little requests. Maybe could be the case for SME or B2B providers. And that you can ask yourself, is it really proportionate to impose a data retention obligation when the outcome is very low?
Thank you very much. Touching on a really important issue and something that I have seen in my practice in the past, really let's say 3/4 of all requests go to a handful of service provider, telecommunication service providers. Wow! So it's also interesting. I'm sure that Ignacio and the colleagues in the Commission are well aware of these specifics. And of course, not only the changing business models and the way the technology functions, but moving another, Michelle, if you thought that the question to you was provocative, the one that I have prepared for Kajik is even worse. So you know that, I mean, we know member states have been always quite keen to ensure that national security is more or less out of the scope, in line with the Treaty of the Functioning of the EU, of course, but this clarification, taking out, keeping the national security the sole responsibility of member states was really very high on the agenda of the wish list of member states. And we have seen it in the legislation, I mean, highlighted, underlined. My question is, isn't it the national security exemption or exception a big backdoor actually for any data retention regime? We know the case law, we know about spyware, some alleged abuses. I said, it's really a tough question, but I'm sure you are the right one to provide some insights.
You said wish list. You said that this is high on the wish list. I don't think it's on the wish list. I think it's there in the treaty. Now, the question, of course, is what does it mean? In the council, we rarely discuss this because, well, it's not EU law, right? There's an exception. So I would like to, before I answer, I would like to kind of, throw the ball back in your court and say, aren't the voices like yours that member states are hiding behind the national security exemption? Aren't they aiming at an interpretation of this exemption so narrow that would deprive it of any meaning? It has to have certain meaning, and I think we need to agree to that. Once we agree, we need to find out where exactly the border is, and the honest answer is I have no idea, and probably nobody does. Maybe the Commission does. I still look forward to seeing the communication on the spyware on Pegasus. That would be cool. There was an idea that EDPS has floated to the court in 2019 when Anna was pleading. It was the Quadrature du Net case, right? 2020. 2019. For a hearing, yes. Whereby situations in which authorities access data from providers on the basis of national security ground is outside of EU law, whereas where there is any kind of legislative provisions defining how does that work, that already is within the EU law, given the privacy context. This was not really liked by member states at the hearing, but we are 6 years later almost, and not much progress has been made. But what I would like to say on this is that in the context of data retention discussion, it doesn't really matter. What matters is that we sit down and start drafting this law. If we have this law, and how this law would look like, I would tell you exactly how it would look like. It will be exactly in the middle, like it always is in Brussels. Once we have this law, and I truly believe we can have it in a way that is respectful to fundamental rights by providing for significant level of effectiveness for law enforcement authorities while making everybody unhappy about not fully reaching their objective anyway, then the national security exception would be less of a context. It will still be used. I guess some member states will prefer to have it understood more broadly, but the need to use it will be less relevant given that we will have applicable legislation in place. So maybe to conclude also, the work of the the objective of the Polish presidency, it also answers your first question, in fact, what in practice we'll do, would be to raise awareness on that and to get people around the table excited about the idea, which we'll do in the form of debates and some more specific questions that we'll share with member states. But my answer to your question about national security is, don't worry, it doesn't matter. What matters is to have a decent law, and then we'll figure out the national security in practice. Thank you.
Ending on this very positive tone, I believe the audience should be given the chance to ask 2 or 3 questions. I'm looking at the people in charge of the time management, but so maybe really just not more than a couple of questions from the audience. I'm sure that there will be quite of an interest. Yes, please.
That's red. Oh, there we go. Thanks so much to the panel for really fascinating discussion. It is, to put it very mildly, a very complex topic. The one thing that I thought that was very striking that was missing from the high-level expert group recommendations was the fact that there was no reference to measuring necessity or proportionality outside of the case law of the Court of Justice. And I think it's very significant that whenever law enforcement of the member states have been asked to provide annual statistics on any data-driven systems, there have always been issues. Now, I'm not placing blame here, but there is a very consistent pattern. And this is somewhat of a significant challenge for a body like the European Commission when it's being told that it has to show the necessity and proportionality of a measure, when it has to review and evaluate whether it's the Data Retention Directive, the Passenger Name Directive, or under Article 5 of the AI Act, the Remote Biometric Systems. We have the same requirement there that annual statistics are going to be provided by the member states. So I'd love to hear the panel's thoughts on how we square the circle, so to speak, because there's clearly some questions of capacity. But if it's not addressed, all that we are doing is not mainstreaming the right to data protection. We're ultimately always going to be leaving it for the Court of Justice to decide.
Thank you very much. It's a trick. It's not tricky. It's a wicked question that, believe me, we also tackled in the law enforcement, in the data protection community. Also, I think it was touched upon also in the statement of the EDPB on the recommendations. However, it's I'll give the floor first of all to Ignacio with the hope that the impact assessment you promised on data retention will include a number of convincing figures, statistics, and also maybe because just to be able to take one more question, if I leave only to Ignacio, I mean, because more or less the justification of the new proposal will be in the hands of the Commission in the impact assessment. So please, Ignacio.
Thank you, and indeed, it's a very good remark. It's one of the first questions that the Court of Justice asked for the necessity and proportionality. What is the basis? What are the statistics? And we are fully conscious of that. Indeed, traditionally, it's not that there are no statistics. There are in some countries, yet not all. This does not only apply to data protection, but I mean to law enforcement area, but unfortunately, it also applies to other areas. So there are ways, because the evidence is not necessarily always quantitative. There can be qualitative evidence. Many consultations, specific surveys, way similar to those that were employed, for instance, for the impact assessment for the e-evidence regulation. So once we launch the impact assessment, there's a call for evidence. We will do our utmost to collect such evidence to justify the necessity and proportionality of the measures. And I can also confirm that during the discussions of the high-level group, necessity and proportionality was in everyone's minds. It was mentioned. I believe it's also mentioned in several instances in the report. And they were also conscious that this principle applies in two levels. It applies at the level of the legislator that needs to be able to justify with solid evidence why these measures are really necessary and proportionate to the end pursued. In this case will be public security and law enforcement purposes. But also it needs to be applied at the application level when the law is applied by the authorities in charge of applying the law, whether it's the judicial authority authorizing access to the data, whether it's the law enforcement authority requesting a specific measure. So I confirm this is in everyone's minds, and it's also in the mind of the Commission that there is this need for evidence, and we'll be seeking it out. That's for sure.
I'm just fully agreeing with Ignacio. Maybe a few more points. The council, very often insists on commissions doing impact assessment before the legislation, and of course, if we call for that, we need to give enough content for the commission to be able to do it meaningfully. Having said that, there is also, let's say, methodologically speaking, there is also limits as to providing a comprehensive set of data that would allow to come up with a precisely measured legislation from this to that. What, however, I think is indeed very important, as Ignacio hinted, is the overall, let's say, level of protection, namely, whether it's a rule of law based country, what is how the judiciary works. And these things are, I think, equally, key in designing the whole system. And to a certain extent, they are measurable. To a certain extent, they are not. There's also, a lot that the Commission is doing in the context of rule of law monitoring that can be helpful. So, bottom line, I think, indeed, you are right. We need to have more kind of evidence-based lawmaking, but it's never going to be sufficient. And there's also other criteria that we need to take into account, I think, when designing the whole structure.
Thank you very much to both of you to this really important, not easy question. Maybe just one more question from the audience, very quick replies, and then just to give the chance for one last sentence. It's not a criminal trial, but still just the last word to our panelists before concluding. Yes, please.
Do you hear me? Yeah. Thank you. I'm from the Commission, DG FISMA, and I just wanted to ask, what do you think about the use of the information that is available online, maybe going even beyond a bit enforcement, use of the information by the public authorities, which actually is everywhere on the internet, but still we are a bit struggling in using it for our purposes, for reporting, and for enforcement for these purposes.
I believe this question refers to as part of the bigger data strategy, the security data space that was part of the data space strategy in 2020, if I'm not wrong, adopted. And maybe if Ignacio, any of you is prepared about not talking, let's not go into open source intelligence, all this stuff, which is more specific, but about sharing of data for internal security purposes. Is there anything that we could expect as an initiative?
Well, when referring to the high-level group, it was mainly focused indeed, almost exclusively on law enforcement purposes. We didn't address the other purposes for which data may be accessed and used, such as for administrative sanctions and others. Although here, I believe that many of the principles that guided the discussions in the high-level group and that will guide the future work of the European Commission will also apply in this case. So it has already been mentioned, the necessity and proportionality of these purposes, the fact that what we call lawful access, every time we refer to lawful access, we are talking about access that is subject to clear, detailed, and precise rules set out in laws and regulation, with effective oversight mechanisms, with effective remedies for individuals, complying with cybersecurity standards, fundamental rights standards. I think this is also valid for other areas going beyond law enforcement purposes. So all these discussions will also should also certainly be useful for extending or contemplating updating tools for access to data in other areas that are not necessarily law enforcement related.
I believe, Ignacio, that actually you touched upon on the key principles, data protection, privacy, harmonization, cybersecurity. So can I also take this as your concluding sentence and just give the floor immediately to Warivin, just mindful of the time, not to be kicked out of the room for the next event?
I will abuse my one sentence to try and answer Nora as well. So I think it's very much a chicken and the egg question, because I have the impression that national authorities will say, we don't have the time to do statistics, we need to work on prosecutions, and we don't have the data, so we need a data retention instrument. And then, but I think, and so, and then this is also a chicken and egg answer, but I think one of the advantages of an instrument would be that then at least you can impose transparency in a new potential law, and that would also then allow you to evaluate.
Again, and for my few words of conclusion, again, I think necessity and proportionality are key, and as well, can't just put everything in in a law at the European level. You have also to take that maybe some supervision at the national level to have that balance between and access to data, and as well European coordination. We do that for the privacy rules and the implementation of GDPR. GDPR is quite simple, in fact, and we on a day-to-day basis are really looking at necessity and proportionality, and we are harmonizing our decision inside the EDPB. So that's kind of a scheme that is really interesting when trying to implement European regulation, and with the aim of harmonizing it amongst countries.
From my side, Plamen, you were a bit skeptical about when I said something more protective than what the court said. I remind everyone that the CJEU doesn't have to be followed strictly by the rule. They set minimum standards, set minimum safeguards to regulate interference with fundamental rights. You can be more protective. You can decide to do less interference with rights. It's not crazy. It's possible. It's on the table. So what we would prefer is obviously to focus on a preservation order approach, a quick freeze approach. We think it's much more targeted. We think it's much more proportionate, necessary, because it's targeted to specific investigation. And I think to your question, or to your remark, which I very much agree with, it would be useful if the Commission was focusing on why this less intrusive alternative isn't suitable compared to more blanket approaches. And this is where necessity and proportionality questions are at the center. Why is it necessary and proportionate to have more than a preservation approach? That is what we need from the Commission and from member states. And I remind everyone that usefulness, convenience, and efficiency are not legal principles. Necessity and proportionality are.
The mindset of every presidency, and I think in particular the Polish presidency, is a bit schizophrenic. On one hand, you need to defend the position of the Council. On the other, you need to look for some sort of rotten compromises all the time. And being here for past hour and a half, I'm kind of feeling the same. I mean, these two things at the same time. I probably would subscribe to the last part of close intervention. You know, the usefulness is not enough, and all of that. That's true. What's also true is that the situation that we have currently with the legal framework or lack of it is not sustainable, and we need to have a legislation, I think. It has to be comprehensive, it has to be balanced, it has to, but it will only be achieved if all parties around the table make concessions. This is what we also have to do constantly with other laws. So, you know, this is a data protection day, and I think it's very important that we kind of gather common position on this and influence the process in a way that promotes fundamental rights perspective. But at the same time, I think there needs to be an acknowledgement that for this to happen and happen in a meaningful way, one would have to find itself oneself in a situation where maybe not all our objectives will be. And by our, I now speak the EDPS language, but all the objectives of the data protection community will probably not necessarily be satisfied, but that doesn't mean that the overall outcome is wrong or is not welcome.
Thank you very much. And now I can only ask you for real applause for these 5 amazing speakers.